Hello everyone and welcome to today's MONDAP webinar in association with Whitewell, who will be discussing how to navigate interim measures and judicial support for arbitration in Spain. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Daniel Rodriguez Galvez is a founding partner at Whitewell. His career spans notable firms like Freshfields, Brookhouse, Duringer and Garrigues. Recognized as a name to know in Spain, in Global Structuring Review 2020, Daniel excels in complex commercial litigation and corporate disputes with a particular expertise in international arbitration. Pablo Martinez Llorente is a founding partner at Whitewell, specializing in arbitral award enforcement, set-aside proceedings, and interim measures. Pablo expertly navigates complex arbitration landscapes, combining his extensive legal experience with his proficiency in Spanish and English. Pablo teaches alternative dispute resolution systems at Universidad Pontificia de Comillas, or the ICADE. And Sebastian Mejia has held the position of Deputy to the Secretary General at CIAM since 2023, where he is actively involved in the management of the institution. He also advises on the administration of arbitration proceedings, as well as in the scrutiny of awards. He has also played a significant role in the drafting of the new CIAM rules, which came into effect on the 1st of January 2024. Now, before I hand over to the panel to begin today's webinar, a housekeeping item. You can submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page. And the panel will endeavour to answer as many questions as possible during our Q&A session, but please do reach out after the webinar for any additional information you may require. It's now my pleasure to hand you over to our panel to begin. Thank you.
Thank you very much, Dan. Welcome everyone. Good evening. And yeah, the session we are going to have today we are going to talk about interim measures and arbitration and about different aspects and angles about this. Okay. Next slide, please. So we've structured the webinar in dividing that into 4 different parts. We'll firstly address the topic of interim measures applied or requested to our judicial body, in my case. After that, we'll talk about adoption of interim measures by an arbitral tribunal, in which case Pablo will be liaising with that, and Sebastian will give us the point of view from an arbitral institution, which I think it's quite interesting. In any event, to end with, we'll have a case study, a real case study, in which we are going to combine the different points, ideas that we've discussed before, in order to present different scenarios and how those ideas and points interact together in order to make the best decisions as to when and where and to before which tribunal or body we are going to request or file our interim measures petition. Okay, so next slide, please. I'm going to start just giving a few points, a few essential points about interim measures according to Spanish law. Well, firstly, I think this is very important in order to know what we are talking about. Time and events during the course of an arbitration proceeding might hinder or might prevent the effectiveness of the award that will be issued at the end of that arbitration proceeding. In that case, interim measures are aimed at ensuring the effectiveness, of that award that will be issued by the tribunal, by the arbitrator, after following the relevant proceeding. Okay. Having said that, it's important to note also that according to Spanish law and the Spanish Constitutional Court, interim measures are specifically linked to our fundamental right to our due process. So I think they are quite relevant and they are quite often adopted and requested by lawyers and supporting arbitration. Next slide, please. So yeah, the first point, we can file our request for interim measures, file that before a judicial body, or we can request them and apply for before the arbitration body. Okay, this is a possibility. The last one was a possibility specifically foreseen in an arbitration act. Pablo will liaise with that. After that, next slide, please. And well, regarding the application before a judicial body, okay, the first question that we have to raise, we have to think of when thinking of when and in which cases it's advisable to file that request for interim measures before our judicial body. Okay, in my experience and according to the regulations, Spanish regulation on interim measures, I think it's advisable requesting those arbitrations or those interim measures in supporting an arbitration proceeding in cases some enforcement activity is requested, is needed. Okay, so for example, if we want our interim measure to be recorded before the land registry, for instance, we need an enforceable title. We need a public title to be recorded before the land registry. Okay, in that case, it makes more sense requesting that interim measure before judicial body. We'll discuss to what extent after that can be, if that interim message has been issued by an arbitration body, in which cases it can be enforced, it can be recognized, etc. But I think the main idea is that when we are requesting some interim measure that in order to be implemented, there's some need of enforcement activity, that the judicial body, I think that would be the most suitable, and it would be advisable to request them before the judicial body. Okay. Another point which is relevant as to when applying for interim measures before the judicial body, the Spanish Civil Procedural Act specifically foresees the possibility of adopting the interim measures without hearing the defendant. Okay, so in a legal pass, which is quite relevant in cases in which there's an emergency, it's a matter of days, adopting that interim measures, and of course ensuring the effectiveness of that award. In that case, it could be a very good point, having that interim measures without having heard the defendant. The defendant will be heard afterwards, okay, but not in that very first moment. And from the point of view of the recognition and enforcement, the interim measures order issued by a judicial body is usually more easily recognized and enforceable, okay, through different scenarios and different regulations, specifically for the within the frame of the European Union Regulation 1215, and after that we will have different internal rules about recognition and enforcement. But that said, it's in principle easier to recognize and enforce an order issued by a judicial body, with some specifications and some specialities that we'll talk about later. Next slide, please. And after that, just a few points about specific regulation included about those interim measures according to the Spanish Civil Procedural Act. Well, the first is, yeah, the answer is yes. Interim measures can be requested and granted by the judicial body supporting an arbitration proceeding. That's the first point. Regarding the time for the adoption, another point which is relevant to consider is that they can be requested and granted even before the arbitration proceeding has commenced or has started. In those cases, well, it's needed to prove and to evidence before the court that we are party at an arbitration proceeding, or that there is a pending arbitration, or in that case that the formalization of the arbitration has been requested. Next slide, please. And well, regarding before which court or tribunal we are going to file that interim measures, before which court, before which judge, there are two main possibilities. The first possibility is the court will have jurisdiction, will be empowered with jurisdiction of the court of the place where the award is to be enforced, and failing that, where the interim measures are to be effective. Okay, those are the two main points, two main places where we can file our request for interim measures. Next slide, please. And yeah, I would like to raise 2 points that in my experience are very often unknown by lawyers, and that may lead to judges and courts to reject many times interim measures, is not considering, not taking into account two of them, or the main characteristics. The main characteristic of an interim measure is instrumentality. They are accessory, they are ancillary to a main arbitration proceeding. So there must be a strict link between the interim measure we are requesting and the object or the action that is brought or to be brought before an arbitration proceeding. Okay, so in cases we are claiming payment of certain amounts of money, attachment of certain goods, attachment of certain bank accounts, would be that perfectly, in which there would be that perfect link between one thing, the interim measures, and what is the action and the object of that arbitration proceeding. Okay, that's that's a key point in order to pick which is to select which is the most suitable interim method for that specific case. And after that, we should be requesting the interim method with the least burdensome for the defendant. Okay, if we can get the effectiveness and ensure the effectiveness for the award just by recording the existence of the arbitration proceeding before the land registry, for instance, it shouldn't be necessary, okay, to file a request for an attachment over certain goods or assets, etc. The first one is less burdensome, is less onerous for the defendant, and that would be the most suitable one. Next slide, please. And finally, to end with, I would like to raise a few points. According to Spanish law, there are 3 legal requirements that an interim measures request must meet in order to those interim measures to be granted by the judge. First is the appearance of good law, formus valid juris, which means that our actions that will be brought before the arbitration proceeding is likely to succeed. Okay, prima facie is likely to succeed. Secondly, there is a danger of delay, as I said before, in cases events may occur that might hinder or might prevent the effectiveness of that award. And finally, applicant must provide security for any damages that might cause to the defendant assets. Okay, and finally, next slide, please. To end with this part of the presentation, just say that though one of the or some of the precautionary measures which are included and foreseen in the Spanish civil procedural law refer to seizure, before to deposit of things, refer to suspension of corporate agreements, among others. Okay, this list is open-ended, so the Spanish law provides for those that can be also requested, although those measures which are especially provided by the law or which are deemed necessary to ensure the effectiveness of the judicial protection. Okay, having said that, Pablo will speak and address the point of interim measures and application for the arbitral tribunal.
Thank you very much, Daniel. As Daniel has mentioned, we are now going to talk about the possibility of applying for interim measures before an arbitral tribunal. And of course, in order to have this possibility, in order to have this option available, we need to have an arbitration proceedings ongoing, and we need to have an arbitral tribunal already appointed and constituted. In that situation, we have the possibility, or we need to analyze whether we have the possibility to apply for interim measures with the before the arbitral tribunal. And yes, this slide is fine. And we are going to analyze this possibility considering 2 scenarios. The first scenario will be the Spanish arbitration proceedings. So the seat of the arbitration is Spain. And we are going to analyze the lex arbitri, which will be the Spanish Arbitration Act. And of course, we need to consider the agreement by the parties. And the agreement by the parties includes the institutional rules and also the arbitration agreement reached or entered into by the parties. Next slide, please. And the first question that we are going to consider is whether it is possible to apply and obtain interim measures from the arbitral tribunal in arbitration proceedings, and if so, on what grounds? What do we need to apply for these interim measures and to obtain interim measures from the arbitral tribunal, granted by the arbitral tribunal? Next slide. As I mentioned before, we need to start our analysis on the Spanish Arbitration Act, and our Arbitration Act includes or provides that the arbitral tribunals are perfectly empowered to grant interim measures unless the parties have agreed otherwise. They have the power to grant these interim measures if they deem it necessary, but there must be they cannot grant interim measure ex officio. There must be a petition by one of the parties. And one thing that is very interesting, because it's a clear difference with the regime before the courts is that security is not mandatory. What the Arbitration Act considers that, or empowers the arbitrator to grant interim measures, and it indicates that they can require a security from the applicant, but it's not mandatory. Next slide, please. After we have examined the lex arbitrii, we now need to analyze the agreement by the parties. And as I mentioned before, part of the agreement of the parties is the rules of the institution. Here you have the Article 28 of the ICC rules, which has a wording very similar to what we have just examined on our Arbitration Act. So the same idea applies. The arbitral tribunal has the power to grant interim measures if they deem it necessary, providing that one of the parties has requested these interim measures, and the possibility of requesting a security is a possibility, is not mandatory. Next slide, please. But I wanted to spend a minute talking about the CIAM rules. I don't know if you know CIAM. CIAM, well, they are our host in this session. Is the Madrid International Arbitration Center, and Sebastian afterwards. Well, Sebastian is a deputy of the secretary, so maybe he will explain a little bit more about CIAM. But the thing is, CIAM wording is quite similar, but it includes some specialties, because CIAM rules specifically mention some standards that the arbitrators may consider when they have to decide on an application of interim measures. So these rules, the CIAM rules are a good example of new elements to be considered if you are going to apply for interim measures, if you are involved in some arbitration proceedings administered by CIAM. So you need to consider whether the application has an appearance of good case on the merits, if there's risk of delay, what the consequences will be in case of adoption of the measure, or the proportionality of the measure in contrast with the consequences for the parties. And again, the security is not mandatory, it's a possibility, and maybe a suggestion, but it's not a mandatory requirement in these interim measures. Next slide, please. And then you can have, there's a typo there, the title should read arbitration agreement. I apologize for that. But after, once you have examined the institutional rules, you need to consider whether the parties have agreed on a specific issues relating to interim measures. Because maybe there's a waiver, maybe the parties agreed that the arbitrators, the arbitral tribunal, will not have the power to grant interim measures, and then it will not be possible to apply for interim measures before the arbitral tribunal. Or maybe the parties agreed that the security will be mandatory in the amount fixed by the arbitral tribunal. So the parties may amend the regime or the general rules on the Spanish Arbitration Act and the institutional rules with their own agreement. So you need to consider those limitations in the arbitration agreement also. Next slide, please. But in summary, after our analysis, the conclusion is that yes, in Spanish arbitration proceedings, you can apply for interim measures before the arbitral tribunal. unless there's a specific agreement by the parties to prevent the arbitral tribunal, to remove the power from the arbitral tribunal, but otherwise the arbitral tribunal is allowed to decide on applications for interim measures, and there might be limitations in the institutional rules or the arbitration agreements, but this is the general regime. And the requirements to be met in order to be successful on an application of interim measures, normally, the things that the arbitrators will consider is the good case on the merits, or whether the applicant has a good case on the merits, if there's a risk of delay, if there's proportionality, and then probably the arbitrators will decide or will consider the possibility of ordering the applicant to post a security, although this is not non-mandatory. Next slide, please. I would like also to analyze the possibility of applying for ex parte interim measures on arbitration proceedings before an arbitral tribunal. And next slide, please. There is no express mention in the Spanish Arbitration Act. So in principle, this would be possible because if you remember, the Spanish Arbitration Act expressly provided that the arbitral tribunal may order or may grant interim measures as they deem it necessary. So in our opinion, it is possible that the arbitral tribunal is empowered or has the power to grant interim measures ex parte without hearing the other party. But then this could change considering the agreement by the parties. For example, the ICC rules, they don't have express mention either, so I think that it would not be a problem. But the CIAM rules, they do have express mention on ex parte interim measures. And the arbitration agreement, of course, it will depend on a case-by-case basis. Next slide. As I mentioned, the CIAM rules envisage expressly the possibility of applying for an ex parte injunction, and there are some rules regarding this application or the standards that the arbitrators must consider on deciding on an application for ex parte interim measures. And expressly that the idea is that, mainly the idea is that the arbitrators must consider the risk of frustrating the requested measure if the other party is heard. So the idea is that only if there is a risk of the interim measure being ineffective in case that the other party is heard, only in that particular case, an ex parte interim measure will be accepted by the arbitral tribunal. Next slide, please. I would also like to mention or to analyze the possibility of enforcing interim measures granted by an arbitral tribunal. Next slide, please. So the idea, according to the Spanish Arbitration Act, the idea is that you can apply for interim measures before the arbitral tribunal, but the arbitral tribunal cannot enforce interim measures. If you want to enforce an interim measure, you need to go to the court. You have your decision on interim measures and you go to the court as if that decision is an award. It doesn't matter if the arbitral tribunal has issued an award or a decision, an order, it doesn't matter. The form or the name that the arbitral tribunal has included in the document or in the interim measure, it is possible to go to the Spanish courts and seek the enforcement of this interim measure order or this decision by arbitral tribunal. Next slide, please. After this, the analysis we have just made, that I would like to remind everybody that was focused on Spanish arbitration proceedings, I would like to spend 2 minutes discussing the possibility of applying for interim measures on foreign arbitration proceedings. That means that the seat is in another country other than Spain. And of course, we have another lex arbitri. So we don't know what the lex arbitri is. It could be any lex arbitri. And then we have, of course, the agreement by the parties. Next slide, please. So if we ask ourselves the same question that we have already asked regarding the Spanish arbitration proceedings, we need to consider again the lex arbitri on first place. Next slide, please. And you need to analyze whether the lex arbitri includes some limitations or the prohibition for the parties to apply, or for the arbitrators or the arbitral tribunal to grant interim measures. And this is something that may happen in some arbitration acts, depending on the jurisdiction. In principle, if the arbitration act is based on the Judicial model law, then there should not be any limitations. Article 17 of the Judicial model law expressly empowers the arbitral tribunal to grant interim measures. So most of the arbitration acts are somehow based on the Judicial model law. So in principle, it should be likely that you have the possibility of applying for interim measures before the arbitral tribunal, but you need to check the arbitration act applicable to the proceedings. Next slide, please. And the rest of the analysis is quite similar to what we have analyzed regarding the Spanish proceedings. So I will only, I don't want to waste your time, so we are only going to analyze whether it is possible to enforce in Spain interim measures granted by a foreign arbitral tribunal. Next slide, please. So the idea I'd like to convey is that it's unlikely because New York Convention does not expressly envisage the possibility to recognize interim measures. The Spanish Arbitration Act does not have any specific provision regarding the possibility of recognizing and enforcing interim measures granted by foreign arbitral tribunal. There is no case law, there is no relevant cases analyzing this issue, and there are different opinions among scholars and practitioners, but the idea, I think that the main thesis is that it will not be possible to recognize interim measures under the provisions of the New York Convention. Next slide, please. In any event, this discussion on whether it is possible or not to have a decision on interim measures recognized by the Spanish courts is, I think, is moot, because it will be impractical. Because if you want to have a decision or an arbitral decision recognized in Spain, you need to have to go to a court and seek the recognition, a declaration by the court recognizing this arbitral decision. And exequatur proceedings are long and burdensome. It would not be, I mean, long and burdensome, considering that you are trying to enforce interim measures, and there is some urgency implied, otherwise you wouldn't need the enforcement of the interim measures. So our recommendation is that instead of seeking the recognition and enforcement of these interim measures granted by a foreign arbitral tribunal, is that you apply for interim measures with the Spanish courts. You have a decision by an arbitral tribunal, and you can go to a Spanish court and seek interim measures, and with the decision granted by the arbitral tribunal, you will have a very good chance of success in seeking interim measures, because you have already proved that you have a good case on the merits and that there is urgency. Of course, the court will ask you to post a security, but that's also something that you need to be ready when you are asking interim measures in Spain. Next slide, please. To end my part of the presentation, I would like to point that I would like to examine briefly when is it appropriate to apply for interim measures with the arbitral tribunal. And the answer to this question is that it is appropriate to apply for interim measures with the arbitral tribunal when the measures are seeking to maintain the status quo. You are not trying to change the situation. You are just trying to keep the situation as it is. So if you ask for conservative measures, injunctions, that works really fine, going to the arbitral tribunal and seeking these interim measures within the arbitration proceedings. Also, it's possible, or it's appropriate to seek interim measures with the arbitral tribunal when you are involved in Spanish arbitration proceedings and you are seeking interim measures that will be easy to enforce, so you can have a decision by the arbitral tribunal and you can immediately go to the court and ask for the enforcement of this decision. For example, when you have an order of attachment, but that will depend on the circumstances, because it might make more sense to go directly to the court to ask for these interim measures. And having said that, I pass now I open the floor now to Sebastian.
Thank you. So I'm going to talk about emergency arbitration with a specific focus on the CIAM rules, but with a bit of a wider key takeaways on what to expect and what to do specifically for an emergency arbitration. Briefly talking about CIAM, we amalgamate the international caseload of the 3 largest Spanish institutions from 2020 when CIAM was founded, and we also manage our own caseload. And as Dan mentioned at the beginning, since 1 January 2024, we have a new rules in place, which essentially try to simplify the procedure, create and adopt the best international practices, and be as user-friendly as possible. Were our 3 goals, and I think we actually have achieved them. They're on our website, and you're free to look them up and reach out to us if you have any questions. On emergency arbitration, back to basics. As Pablo mentioned, arbitral tribunals usually have a power to grant interim relief, and usually you may want to actually go to the arbitrator instead to the courts, so that they can give you interim measures the majority of the times, because that may be faster, depending on what the courts of the seats are. That may be faster than obtaining judicial interim measures. But at the beginning of every dispute, you always have a problem. You have that interim moment between when the dispute actually starts, when you start fighting, when you know that you're going to need to file for an arbitration, and the moment where you have an arbitral tribunal in place to actually issue that interim relief. And that's where emergency arbitration comes in. In emergency arbitration, what we do is we appoint an interim arbitrator who, for that specific period of time until the arbitrator is, under the tribunal is appointed, will issue any interim relief that is needed to protect and that is urgent, that cannot wait until the appointment of the tribunal, and will issue that interim relief that is needed. This emergency arbitrator issues normally an order, but it can also issue an award, and that will depend on the rules of the institution that you have chosen. And what is important is that they usually may order all types of interim relief that a full tribunal could adopt. There is only one exception, which are ex parte or no notice measures, because under CIAM rules, at least, and under the majority of international rules, emergency arbitrators cannot issue ex parte orders. But this distinction between order and award is not perhaps as relevant under Spanish rules, but it may be relevant for international enforcement, or if you don't have as clear rules as the Spanish Act has, that regardless of whether it's an order or an award, you can take it to the courts for enforcement. What you want generally is for, if you are looking for enforcement, you will want it to be reflected in an award, and for that you need rules that specifically allow the arbitrator to establish their order in an award. It may take a bit more time because it needs to be scrutinized, but you will have an actual award that, depending on the legislation, we will talk about that later, can be enforced. Next slide, please. So very quickly on the requirements, because they've already been addressed. The issue is that with emergency arbitration, you have an additional set of layers of requirements than those you have for normal interim relief. And you have formal, substantial, and procedural requirements. Formally, it's very similar to the requests, to the normal documents you will need to file for a request for arbitration. So you need to file the required documentation, identify the parties, provide the contract, identify the arbitration agreement. But there are two important issues here. One is that with a request for arbitration, you can be a bit more lax with this. You may be given additional time to supplement your request for arbitration. You may want to add an additional document at a later time. In an emergency arbitration procedure, that's something you want to avoid because time is of the essence. If you want it to be done quickly, you want the court to work quickly with your case, you want to make it as easy as possible for them to identify the arbitration agreement and to identify that you want an emergency arbitration. And the second one, very important, it's very mundane, but it is essential, is payment. With a normal request for arbitration, you would just file administration fees and wait for a request for advance on costs. When you have an emergency arbitrator, you want to pay all the fees in advance and make sure that they're in the institution's bank by the time you're requesting the emergency arbitration. Why? Because the court will not initiate emergency arbitration proceedings. They move very fast. So the court will not initiate the proceedings until they have the money. And they will give you 5 days to pay if you have it, but those are 5 days you have lost. So that is something that you want to do, and that's just a practical point that you want to do. Substantially, the requirements are generally the same to usual interim relief to a tribunal. You have to prove prima facie jurisdiction, you have to prove prima facie success on the merits, you have to prove a risk of delay and a threat of irreparable harm, and you have to prove proportionality. But there is a specific one exclusive to emergency arbitration, which is urgency. You not only have to prove a risk of delay, but you need to prove that that risk of delay is going to materialize in the period between initiating the arbitration and the appointment of the tribunal. You need to prove specific urgency, that you need emergency relief now, and that there's no way you can wait for the appointment of the tribunal. If your relief can wait, the emergency arbitrator may not issue the relief. And finally, a procedural point. You need to file the request for arbitration because, as Daniel said, emergency arbitration as interim measures is instrumental. You cannot just file it and forget about it. You need to file the request for arbitration within 15 days of the request for interim relief to show essentially that you're going serious. Otherwise, the arbitrator may not issue the order you asked for, or if they issue it, it may not be coming. If we move on to the next slide. Very quickly, the procedure, this is the general timeline of a request for emergency arbitration. You request for it. The court will appoint your arbitrator and send them the file within 2 days, provided you have paid the advance on costs. Within 2 days, that arbitrator will send you a draft procedural calendar and establish the emergency arbitration proceedings. And they have an obligation under the rules to issue a decision within 50 days from receiving the file. This can be extended in exceptional circumstances, but if you look at the average duration of 12 cases from 2021 to 2023 on CIAM, which is one of the courts from which CIAM stems, the average duration of an emergency arbitration procedure was 15.6 days, which is quite fast. Just as a quick tip for practice on this proceeding and on this timeline, when you prepare your request for emergency arbitration, when people request just a normal initiation of an arbitration, they play games sometimes. They're tactical on what they say and what they don't say on the request for arbitration. On your specific request for emergency arbitration, you may want to be as clear as possible, and you may want to advance your case. Why? Because when you're discussing procedural calendar, you may be able to be in a position to say to the arbitrator, I've already said all I wanted to say. Just give the other party 5 days for their case and then decide as quickly as possible. If you really want your decision to be quick, be as detailed as possible in your request for emergency arbitration. In the procedural calendar, say you've already said all you had to say. Just wait for the reply, and then you will have a decision quite quickly. The costs are on the slide. I'm not going to delve into them. Next, there is a typo that it's 10,000 for the arbitrator's fees, not 5,000. If we move to the next one very quickly, I just wanted to touch point on some elements to consider specific to emergency arbitration. One is consent. Normally, when you go to arbitration, you need to prove that you have consented to arbitration. You also have to do that with an emergency arbitrator, but depending on the rules, you also have to prove that you have consented specifically to emergency arbitration. Usually, if your agreement to arbitrate postdates the rules that provide for emergency arbitration, that's not a problem. But with some institutions that have modified the rules to include emergency arbitration, CIAM is not one of them. CIAM started with emergency arbitration from the beginning. But in some institutions that have modified them, it may be that your agreement to arbitrate is previous to that, and that the rules say that emergency arbitration only applies to agreements that come after their entry into force. If that's your case, for example, if it's a long-standing master agreement or a long-standing sales agreement, you may want to amend that before you come to a dispute, because otherwise you will find that you have no standing to bring an emergency arbitration. Second one, emergency arbitration should be an alternative to courts. And when you choose an institution, you need to look for a specific clause that says that, a specific article in the rules that say that it is not exclusive, it's an alternative to the courts. Why? Because otherwise, depending on the seat of your arbitration, you may find yourself in some trouble. An example of this is the UK Arbitration Act. The UK Arbitration Act allows for the courts to issue interim relief, as it says, in the case of urgency on application of a party for the purpose of preserving evidence or assets. The problem is that Article 44.5 says that that power is limited to the extent that the arbitral tribunal has no power or is unable for the time being to act effectively. So essentially emergency arbitration. But if we look at the General Metals Victimes case, what happened is that in that case, the applicant, General Metals, requested emergency arbitration from the LCIA. The LCIA decided that it would not order emergency arbitration. Well, the LCIA emergency arbitrator, not the court, decided that it would not order emergency arbitration because the counterparty had given sufficient assurances that they would pay, and therefore rejected the request, saying it was not sufficiently urgent. The party then went to the court, and the court said, you have already lost your right to come to the court because this is not sufficiently urgent. Once you can go to the emergency arbitration, you lose your right essentially to come to the court. So you want to make sure that that is not something that happens to you. Even though the LCIA had this type of clause, you need to make sure that you're choosing your court, your seat, you're choosing your rules. Next, quickly. Finally, very quickly, on emergency arbitration, the key issue: urgency, urgency, urgency. Emergency arbitration is fast, and so you want to make sure that you're showing that you want to act decisively, and you want an institution that does the same, and that it selects an arbitrator that is available and that is robust on procedure. Generally, an emergency arbitration order, whether it's an order or an award, will be binding on the parties. The issue comes down to enforcement, and it will depend on the law of the seat and or on the law of the jurisdiction where you wanted to enforce. If it's international, there are states that allow for the enforcement of emergency arbitration, some don't. But the reality is the majority of emergency arbitration measures are complied with voluntarily, normally because the parties don't want to get in the face of the eventual tribunal. As I said, usually you cannot apply for ex parte measures, and a measure can usually be amended both by the issuing arbitrator and by the next tribunal. I think we can move to the case study and read it quickly.
Thank you, Sebastian. Thank you. Well, we have prepared a brief case study so we can put into practice what we have just discussed on this webinar. If we can move to the next slide. Here we have two parties. The first one is a construction company named Construction Company, so nobody gets confused. This construction company is specialized in large-scale infrastructure projects. And then we have Properties. Properties is an investment company which is financing construction and development projects. Next slide. So these two parties, construction company and Properties, entered into a construction contract for a new skyscraper in downtown Barcelona. And according to the contract, Properties agreed to finance the project, and construction company committed to finish the works within the following 3 years. And in order to guarantee the fulfillment of the contract, construction company provided Properties with a first demand guarantee for an amount of 12 million euros that was issued by Construction Bank. Next slide. So the situation is that after 2 years since the beginning of the works, the construction is significantly delayed. Properties consider that the works will not be finished for another 2 years, which is 1 year delay from the deadline included in the contract. So Properties is considering the possibility of executing the first demand guarantee to recover part of its investment, because the Properties thinks or is of the opinion that construction company is in breach of its obligations under the contract. However, construction company maintains that the delay is due to Properties delay in approving some designs, and so the execution of the guarantee will be unfair. So the construction company will be opposing the certiorari. So they will be arguing that Properties has no right to execute the first demand guarantee. Next slide, please. Of course, they have an arbitration clause in the contract, and so construction company is in a situation where they are considering the possibility of requesting an interim measure to prevent Properties from executing the first demand guarantee. And the idea is that this execution, this calling of the first demand guarantee, could cause irreparable damages, irreparable harm to construction company business and reputation. So if we can go to the next slide. So we have a first scenario. Here in this first scenario, construction company is a Spanish company, Properties is also a Spanish company, the seat of the arbitration is Madrid. The arbitration is administered by CIAM. Construction Bank is based on Madrid. So as you see, everybody is on Madrid. And the situation is that Properties has already sent a demand for payment to Construction Bank. The arbitration proceedings have not been initiated yet. In this scenario, we need to consider whether it will be better to go to the Spanish courts, whether it will be better or possible to go to the Arbitral Tribunal, or if it will be better or possible to go to an emergency arbitrator pursuant to the CIAM rules. So, Daniel, do you want to comment?
Well, given that in this case, all the points and elements are located in Spain, I think there's an additional element in this case, which is it's important to note and to know how judges and courts work regarding and consider interim measures requests, and how an arbitration tribunal, in cases an emergency arbitrator, might consider the case. In this case, I think, given the way we know how Madrid courts consider these type of requests, I would be very inclined to think of probably Madrid courts to seek to request the interim measure before the Madrid courts. But I think that's the case because we know how they work, and all the elements of the dispute are located in Madrid. In this case, I think it would be it would make sense to apply for courts instead of the arbitration. How there's not I'm not excluding the other possibility, but I think Madrid court could be a good possibility in this case.
Thank you. Well, I know that we cannot go to the arbitral tribunal because the arbitration proceedings have not been initiated yet. So there is no arbitral tribunal to go to ask for interim measures. So I don't know if this is something that we can remedy somehow. Sebastian?
I think here emergency arbitration would be a viable option. For me, it would, in my advice, would actually not be to be an and or, but maybe throw everything. And for one particular reason, if you initiate emergency arbitration, you may have a decision within 10 days, which I'm not sure it's as easy to obtain with the courts. Maybe if you have an ex parte request. But ideally, you would initiate emergency arbitration proceedings against properties, against the party, to enjoin them from proceeding with the demand for payment. But then also perhaps initiate a court case against both properties and the construction bank with an ex parte application to just at least limit the decision and tell them not to do anything until the emergency arbitrator decides or until the court decides. That would at least gain you some time perhaps. And that shows the key advantage also of going to the courts, which if you go to an emergency arbitrator, you cannot address the bank. If you go to the courts, you may be able to address the bank and bring them into the case and have them reply to a court. They may perhaps just ignore an arbitration.
Yeah, it's also important to know that we are considering an interim measure that consists of, well, is referred to an enforcement of a bank guarantee, in which case, as Sebastian said before, the time is a key element. It's a matter of days to stop the enforcement of a bank guarantee. So I think an emergency arbitrator or courts and tribunals, in this case of the bank, I think would be very relevant, and it's a matter of days. The way we can stop that through the interim measures. Okay, so both options will be viable in this first scenario. So next slide, please.
Well, here we have a different scenario. In this case, construction company. In this case, construction company is a Spanish company. Properties is a Danish company, but the seat of the arbitration is Stockholm, Sweden. The arbitration is still administered by CIAM. The construction bank is also based on Stockholm, Sweden, and the situation here is also one where properties has already sent a demand for payment to construction bank. In this case, arbitration proceeding has not been initiated yet. Well, considering this situation, I don't know, Sebastian, what will you do?
I don't know if it would change much. The only difference would be you wouldn't go into the courts in Madrid.
Yeah.
There's probably not much you can do there. You may go to the courts in Stockholm. It'll depend. Going to the courts in Stockholm will depend on how easy it is then to enforce that in Denmark. The good thing is that courts in Sweden, as the courts in Spain probably, but they're very, very robust. They're very robust in case management. So you will probably get a very, very good decision. They're very robust in support of arbitration. So it's also quite a good seat to select. Again, I think perhaps a dual approach where you have the emergency arbitrator and you go to the courts. My key question here, you may also want to go to the Danish courts, depending on how they work. My question here will also be where is the construction bank based? Because then you have like a multifaceted litigation where you may have to do it, but you have to do it very well.
Absolutely.
And that's where perhaps the arbitration helps.
I think not being aware of and not being aware exactly how Stockholm or Sweden courts work in terms of interim methods supporting an arbitration proceeding, or even in Denmark, could be a key element to make a decision in this case. So yeah.
Absolutely.
No, the other.
We're going back.
I don't know what is happening to the slide.
Let's go there.
Thank you very much. Yes, of course. We are not analyzing this webinar other possibilities as, for example, going to Swedish or Danish courts, but they will be an option on this case. Now we are here on the third scenario, and it's very similar to the previous scenario. Construction company is a Spanish company, properties is a Danish company. The seat of the arbitration is Stockholm, but the construction bank is based on Madrid. Considering this scenario, what would be the preferred option?
Well, I think one person would say that an emergency arbitrator.
The court in Madrid will be.
Well, court in Madrid, I think it's said well, the construction bank is based on Madrid. You can address and file that request before Madrid courts, and you may gain some time filing that before Madrid courts, being aware of the way they work in terms of the message. But I think the construction bank, which is the addressee of the order to be issued by the court or by the judge, I think is a key element in this case.
Thank you. So if we can go to the next slide. Well, this is the last scenario that we are going to analyze. It's very similar to the second scenario. Spanish company, Danish company, seat of the arbitration Stockholm, an arbitration administered by CIAM. The construction bank is based on Stockholm, and the situation is that the properties has not sent a demand for payment to construction bank yet. The arbitration proceeding has been initiated, and the arbitral tribunal is already in possession of the record. So in this case, you cannot go to an emergency arbitrator. You cannot apply for indemnities with the emergency arbitrator because you already have the arbitral tribunal. And on this case, I think it could make sense to go to the arbitral tribunal, especially because the property has not sent a demand for payment to construction bank. So it's possible to seek an injunction, to seek an order to properties, so they refrain from executing the bank guarantee, and that would be a possibility, and I think it would be a good possibility in this case. Yes, I think we are out of time. I don't know if we will have time for any questions. Dan,
There's one question in the chat. I don't know, Dan, if you want us to.
Absolutely, absolutely. I think that we'll have time to take that question, but before we move on to that, I just wanted to say thank you very much for that incredibly informative discussion, for your presentations, and for the case studies as well. I'm sure that our audience appreciated it. We will be sending a copy of the recording along with the slides to you after this session. So our question has come in from Abirup, and it's actually for Sebastian specifically, but of course, please do jump in if you have an answer. Can parties request the emergency arbitrator to pass her in order in the form of an award and not just an order for interim measures, as this may help with enforcement?
The answer is under CIAM rules, yes. Under other rules, it will depend, because some rules do not allow for arbitrators to emergency arbitrators to actually issue awards. Some rules just provide for orders, and if all you can do is send an order, that's all the power the emergency arbitrator has. They don't have jurisdiction to issue an award. Under CIAM rules, you can ask for an award, and it will be up to the emergency arbitrator to decide if they issue an award or an order.
Excellent. Brilliant, brilliant. Well, thank you very much for that answer. And looking at the time, I think we will have to wrap up there. But if you do have a question that you'd like to put to the panel and you haven't had time to send it in today, please do get in touch. We'll be in contact with their contact information. So please do reach out if you have a question. But thank you very much once again to our panel, to Daniel, Pablo, Sebastian. We really appreciate your time and your insights today. And thank you also to our audience. Wishing you all a lovely rest of your day. Goodbye.
Thank you very much.
Dan.